Welcome back, everyone. Today we're dropping straight into a Florida courtroom where a man tried to lean on the classic, private citizen argument, thinking it would get him out of trouble. But he quickly learns the judge presiding over this case has no time, or tolerance, for sovereign citizen-style defenses. What follows is a rapid unraveling that doesn't go the way he planned. Stick around, because this one escalates fast.
Come on up. Yeah. All right, Mr. Baker, you're before the court today for your arraignment. And let's see. You're not. Have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself, or do you wish to have a public defender to represent you?
No, sir. I'm representing myself.
Honestly, after seeing that haircut, I can't say I was surprised he decided to represent himself in court. But there's always this strange pattern where some of these sovereign citizen cases come with the most unconventional personal presentation and even more unconventional legal arguments. It almost feels like the courtroom is about to hear something completely off the rails before the judge even says a word.
All right, you're before the court today for your arraignment. You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, count 1 and 2. Those are both third-degree felonies, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is drive my license, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
Not sure if you caught what the judge just said, but this isn't a minor situation. We're talking about potential exposure of up to 30 years if there's a conviction. This is the kind of moment where every word in court matters, and trying to argue your own interpretation of the law could seriously backfire. The judge even pointed out that you have the constitutional right to a free attorney, and at this stage, that option might be the most important decision you can make before things get any worse.
If you'll raise your right hand to be sworn in.
Yes, sir.
All right, Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business.
All right. What kind of business?
A cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to make this decision?
Keyword diagnosed, though you've got to wonder if, years down the line, some researcher is going to look back at this whole sovereign citizen phenomenon and try to make sense of it as a very specific moment in time. Maybe they'll conclude it was just a mix of internet theories, misunderstood legal concepts, and people confidently pushing arguments that never quite held up in court.
Right. You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in preparing pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
Comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? All right, Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm going to ask that you enter a plea at this time.
I'd like to file 2 motions on the record as well, sir.
I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and enter your plea.
I am the plea of not guilty.
Okay. All right, you're filing motions.
Yes, sir. I
You
got
have copies for the state.
Yes, I do.
For a brief moment, you almost think maybe this is someone who understands how the system works, someone who can actually handle motions, follow procedure, and navigate a courtroom properly. But that illusion doesn't last long. The second the arguments start, it becomes pretty clear this is going in a very different direction than expected.
Okay.
I got a declaratory judgment, and I want to furnish this bond to the clerk
You file it. Go ahead.
for my release from the Bay County Jail today.
Okay.
That's the declaratory judgment. That's for the clerk only.
Now you're providing a copy of the state, everything you've given the clerk.
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk.
Anything you file that you want me to consider, you have to provide a copy to the state, sir. As you're representing yourself, you have to know those rules. If you don't, you're going to mess up.
I understand that.
If you're not providing to the state, I'm not going to consider it.
Okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're indigent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today.
That's a nice idea, but somewhere along the line you were clearly given the wrong information. Being arrested on felony drug charges doesn't get resolved just by filing a piece of paperwork and expecting an automatic release. I don't know who explained it that way, but I hate to be the one to break it to you. This isn't how the bond process works in a courtroom setting.
I filed my eligible obligation.
What are you talking about?
Sir?
What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not going to let you represent yourself. I promise you. He's already entered a not guilty plea. We'll set this for a pre-trial. We'll set it for don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December, when's that motion day in December? December 19th at 9:00. Sir, you may, if you're going to do the sovereign citizen and all that, you may want to consider having the attorney.
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
6 in one hand, half dozen in the other. At the end of the day, the label doesn't really change what's happening in court. Whether someone calls themselves a private citizen, a state national, or anything else, the judge is still going to look at the arguments the same way, based on the law, not the terminology being used.
If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that.
Okay.
So we'll see you December 19th at 9:00.
It's no problem.
That's enough. I don't want to hear another word.
Okay. I'd like to also.
I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date. I just did.
That's definitely one way to torpedo your chances of successfully representing yourself in court. And while a court date has been set for mid-December, there's an important moment here worth noting, when the judge makes it very clear who has jurisdiction, and who's actually in charge of the proceedings. It's one of those reminders that, in a courtroom, the rules aren't optional and the authority of the court ultimately sets the tone for everything that follows. I'm honestly looking forward to the next hearing. The judge has now ordered counsel for the defendant, but something tells me this isn't going to go quietly. There's a strong chance things could get heated again when court resumes, and we may see more pushback in the process. If you enjoyed the video, make sure to hit the like button, drop your thoughts in the comments, and subscribe with notifications turned on so you don't miss what happens next. I'm Team Saju Shah, and I'll see you in the next one.